Go ahead and turn this stuff on. Well, it won't come on yet because I need to change cameras.
So whatever you have on and whatever audio is going straight across YouTube.
Right upside down with the other cameras. And the stuff on. Well, because I need to change cameras. That's going to be an issue.
So whatever you have on, whatever audio is going straight across YouTube.
Right upside down with the other cameras and stuff.
Go to where your YouTube's at.
Because I need to change
100%.
cameras. That's going to be an issue.
Whatever you have on, whatever audio is
I think
going
it's
straight
under the
across
edge.
YouTube.
Right upside down with the other cameras and stuff.
Go to where
Because
And you can close this out. You don't have to have this open.
Because
The upper X up there. Yeah.
Perfect.
Because you're still live on Zoom.
Yeah.
So you don't have to have your YouTube.
Right.
Oh,
Okay. Because yeah, that we couldn't function with it
No.
echoing like that. We want to make sure it's not doing that on the YouTube channel, which I don't believe it will be. Well, you want me to do some, be in there and you can tell me what to do? Do you want me on there so you can hear that? Okay. She had a runner. She broke her chain. And that ran all over the place while I was oblivious to that.
Out back?
No,
Your house.
at my house. Morning.
Judge, I'm just gonna own it.
Uh-oh. Uh-oh.
I messed up yesterday.
What that?
The news crew, I asked you to video it off what you're doing.
Mhm.
Wanted to
Yeah.
warn.
Yeah.
I thought, well, when there, maybe I'll scan one and send it.
Right.
I forgot. It hit me at that time, I'm not so, if they,
What, on what?
yeah, I got it written down, so I wanted to do it. Yeah.
We're live on YouTube.
I'm across them. Now, where am I? Everything turned on?
We don't have.
So how does the YouTube work?
I'll go in. So can you hear me? Can you hear me now? Is it coming through? Hello, hello, can you hear me? Okay, girls, come on. Come on, girl. Can you hear me? Can you hear?
That's scary for a few minutes, but I don't know what's going on yet.
Okay. So it's a minimum.
Donna's down there right now.
Okay. So no, it's one week. Thank you.
I'll move. Yeah. I get to go back to mountain.
Well, what's going on? Who's going to be on booking?
Booking is Sarah's, Tyler went upstairs.
Okay.
For now.
Sarah's.
See what happens.
Okay. Thank you. I don't have any from down there yet.
Chase, D7. What's that?
That's, I got these stuff as well. That was supposed to be snakes. Wow, he says that. I thought he said that. Wow.
Oh, we go back there and find Chase. If you have to, go door to door, for fuck's sakes.
They can't do that. I thought I put D7 by it, I'm sorry.
No, you such these things.
Write this at the door, gentlemen.
I don't know, I just asked for these stuff. Throw pizza.
All right, which one of you is Tony Lambert?
Me.
You need to fill out this for a public defender for me, please, unless you hired your own attorney. Okay. Here's that, let me get you bill and a clipboard. Everybody else has one there. Name, address, phone number, date of birth, last 4 years social. You pay any bill, write down how much you pay, if not, put all zeros, sign right there. Thank you. Don't say that.
Oh, I might need you to be okay now this afternoon.
I can't do that, I got cough due to cold. I'll send Therese over so she can poke the bear in the eye for second shift.
Do what?
I said, we'll send Therese over so she can poke every bear in the eye for second shift.
Send her back to Logan.
I thought he was in booking.
Yeah.
All rise, please.
Thank you. Please be seated.
I'll be right in, Judge.
Liberty.
Jim,
Jim.
Good morning.
does Andrew have the?
Good morning. Good morning. Good morning.
Goes out here. Had it yesterday. and
Oh,
I just need
you-
that for the
okay.
entries.
You know where they took it?
She said she gave it to Andrea.
I'm sorry. I dropped my Roger off.
I know.
Here.
You're hearing in there. Good morning. Give us a second. She is a mess. She got loose this morning and I thought, oh, I yelled and she had all this stuff tangled to her because we live out in the country. Yeah.
That was weird. I just reheard our conversation.
Because
The delay.
there's a delay. Yeah.
My earbuds in.
I'd be like, give me a good game.
Yeah. Please, I. Yeah. Yellow outfit, the front shoes. I love Chaz though, you know.
Yeah, he's not afraid.
So,
Put it out there.
his little daughter. They did everything together. I can tell them somehow, but it's that.
What's your name, sir?
Kevin. Dog.
Okay. Thanks, Kevin.
Yes. Who do your shit? My shit. You don't need to stand there watching me. I know what I'm doing. Almost like for something.
Participants. I'm going to mute and then ask you guys to unmute just to make sure that way other people, when they get on here, won't be able to be heard. So give me a second. I'm muting all. And now I'm going to ask you to unmute. Sorry. There. Thank you.
Just before we start, Judge,
Yes.
I received a text message from Brandy at the Sheriff's Department. that said title posted bond
Okay.
and was scheduled this morning at 8. For an arraignment while he was in jail. She said she wasn't sure whether he was told or not what to be here. So
Okay.
I don't know if we wanna do a summons for him,
I'll see if he
if he
shows up.
doesn't appear or issue a warrant, but
Well, we'll have to see what he was given when he was released, what the how did he get released if I haven't set his bond?
I don't know, Brandy just said title posted bond and was scheduled, so I don't know if he'll
What-
show up at the courthouse.
Was it a bind over?
Yes,
Okay, so there was a bond set. What was the
Yeah.
amount?
50,000, I think it was no 10%.
And so, do you know what, if it had today's hearing on it?
No, the bind over didn't have, see what I'm.
So we probably will, if he doesn't come, if he doesn't know to come, then we'll probably have to do a summons if we have, assuming. County court has a good address that they sent over.
Who is this on the screen?
This is Mr. Dalton.
State versus Dalton.
We are on record in the Meigs County Common Pleas Court and State versus Dalton, 26 CR 076. For the record, I'm Linda Warner, the Common Pleas Court Judge. I need to notify you that this is being live streamed through our Zoom, which is open to the public, as well as our YouTube channel, which is open to the public. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You have to answer loudly. Oh, did you get remuted? You got remuted. Here, I'm asking you to unmute. So do you swear?
Yes, I do.
Okay, if you would, please state your name
Kevin Dalton,
and your address.
7056 Wood Road.
What
Albany,
road? 705 what road?
Wood Road,
Wood,
Albany,
Albany, okay. And your phone number?
698-0740-698-6312.
And your email?
It's kid, KID 1313 at outlook.com.
Thank you. And you don't have an attorney with you, but we'll talk about getting you one, or if you're gonna hire one in a moment. We do have the state's attorney. She is going to identify herself.
Yes, from Cindy Whiting, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
And given the charges in the indictment, there would be a victim or victims. Were the victims notified? This is Kevin Dalton.
Yes, Your Honor.
Okay, are they present?
No.
Did you expect they would be?
Okay.
Okay, so we're not expecting them. You were indicted by the Meigs County Common Pleas Court Grand Jury July 1st, 2026. It's a 2-count indictment. I trust you received a copy of the indictment. Is that correct?
Yes,
Was it more than 24 hours ago?
yes,
You have the right to have the indictment read to you in its entirety, word for word. Or if you're good at reading and understanding written English, you may waive the reading. Do you want me to read it, or do you want to waive the reading?
I'll waive the reading.
Count 1, I'm gonna tell you the potential penalties since you don't have an attorney. Count 1 is receiving stolen property. And that is a felony, the 4th degree as charged, which carries potential penalties of 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, or 18 months in prison, a fine of up to $5,000 or both. Do you understand the potential penalties for count 1?
Yes,
Count 2 is violating a protection order, a felony of the 5th degree. It carries potential penalties of 6, 7, 8, 9, 10, 11, or 12 months in prison, a fine of up to $2,500 or both. Do you understand the potential penalties for count 2?
yes,
We're going to enter a not guilty plea on your behalf at this time, and you need to have an attorney to assist you. If you cannot afford one, one can be appointed. Are you going to be able to hire your own, or do you need one appointed?
I'm probably gonna need one.
Okay, so you have to fill out paperwork there, swearing your income and asset information, but assuming you're eligible, we'll appoint
Denise Bunt.
attorney Denise Bunce. Next, we'll talk about bond. What's the state's position on bond?
Yes, Your Honor, the state would ask that bond continue as it was previously set in county court at 50,000 with 10% permitted, along with no contact with the victim.
With 10% permitted.
Yes.
Your Honor, I would have to ask for an OR bond, or there might as well not be one for me because I don't have any way to do that.
Okay. So that I was gonna ask you what your statement is on bond. So you're asking for an OR bond?
Yeah, that's the only way I would be able to do that, cause, I don't have any other way to do it.
Given the nature of the charges, in particular, the violating protection order, I'm going to leave the bond or reset the bond in my court the same as Judge Barr had, which is the 50,000, but with 10% permitted, plus a GPS monitoring system, which is an additional $250 per month, the first month payable up front. And we'll schedule hearings. So in anticipation that you might not be able to make the bond, it'll be a fast hearing schedule. So with that, the hearings will be.
We will set an initial pretrial for July the 29th at 11.
5 days after my birthday.
Well, you'll remember that one.
Yeah,
A final pretrial and motions hearing for August the 12th at 10. And then a jury trial date of September the 1st at 8.
Those dates will all be on the paperwork you'll get today. They'll be on page 2. I neglected, however, to mention in your conditions of bond that it's not only the dollar amount, but assuming you do make the bond, I want to make sure you understand you cannot use drugs, alcohol, or other mind-altering substances, and you will be subject to random drug screens. You are firearms disqualified. You cannot own, possess, obtain, use, or attempt to do any of those things with a firearm while the case is pending, and you can't get in any other trouble. No contact with law enforcement resulting in charges or arrest, and no contact with
Holly McGrath.
HOLLY McGrath. No contact with Holly McGrath directly or indirectly. If you do that, you'll be rearrested and the bond will be set at even higher. So do you understand the conditions of bond?
yes, I do.
Okay. Also, there'll be an order that you have to be fingerprinted, photographed, and DNA collected on this particular indictment. Even if you've had that done in the past, each indictment has to have its own. Do you have any questions?
Yeah, I have a son with Miss McGrath, right? And she was had postpartum, like I had to go to classes and stuff to get her.
Well, just a moment. Because she's a victim, you may not want to ask any questions on the record because anything that could be used against you. So I would advise you to go back to your cell, reach out to your attorney who can then address that question. And if it's appropriate to state it in front of me, she can advise you of that. I'm just afraid that you might say something that could be.
I'm sorry, but I mean, is this just something I have to say? It's a fact because I mean, I love my son to death. And I took care of him every day for 3 years, right? And solely, I did everything for him. And then just as soon as I got him potty trained and I got him saying half his ABCs, 3 years I haven't saw him. Give me 2 years paper, Your Honor. I did the 2 years. I've got myself together. I got on my feet. I got a way to see him and take care of him and visit him. And I thought I was within my rights to ask to see him. That's all I did.
Okay, again, you need not make any statement because what you telling me that today is not going to change your status because all I know is what it says on the indictment. And so you telling me that is not going to result in me doing anything different than what I've done today. So don't say any more about that. I understand your frustration and the emotions behind it, but you have to get through this process because the grand jury did indict you on those things. So you need to get with your attorney and get the information that the state has and why they brought these charges to resolve it. Because telling me that today without both sides here and without evidence on the record is not going to change anything. I know that's frustrating, but that is the way this works.
Don't make sense.
Okay. All right. Do you have any questions about the procedure?
No.
Okay. We'll let you go ahead and then we'll have the next person. You can go back to yourself. Thanks. Who do we have next?
Either Anderson or Lambert.
Okay.
They're all 4 in here, so whoever you want, just we'll switch them around for you, ma'am.
Okay, that's great. Who have I got now?
Lambert.
Lambert? Tony, right?
Yes, ma'am.
State versus Lambert.
We are on record in the Meigs County Common Pleas Court in State versus Lambert, case number 26 CR 083. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, Mr. Lambert. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
State your name.
Tony Lambert Jr.,
Junior, okay. What's your date of birth? Because we don't have a junior on this.
10/27/05.
Thank you. So that is you, but we'll note for the record that you are a junior. What's your address?
865 Brownell Avenue, Middleport, Ohio.
Is that the apartments or as a house?
The house.
Okay. And your phone number?
Do not have one.
Do you have a phone where a phone number you could use where someone would take messages for you?
740-339-8206.
And whose number is that?
That is my boss's number, and the person who I resigned with, his name is Travis Ward.
Travis Worth?
Yes, ma'am.
Okay, thank you. And your email?
It is Tony Lambert 259@gmail.com.
Thank you. And you don't have an attorney yet. We'll talk about that in a moment. We do have the state's attorney.
Yes, Your Honor, Cindy Whiting, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
Right. And we are here because you were indicted by the Meigs County Common Pleas Court grand jury on July 1st. It was filed July 2nd. It is a 9-count indictment. Did you receive a copy of the indictment already?
Yes.
Was it more than 24 hours ago?
Yes, it was on the 2nd.
Okay, great. You have the right to have the indictment read to you in its entirety, but if you're good at reading and understanding written English, you may waive the reading. Do you want me to read it to you, or do you want to waive the reading?
Waive the reading.
Okay, I will tell you that the potential penalties, since you don't have an attorney with you, count 1 is felonious assault. It is a felony, the 2nd degree, which carries potential penalties of 2, 3, 4, 5, 6, 7, or up to 8 years, definite prison sentence, up to 12 indefinite prison sentence, a fine of up to $15,000 or both. Do you understand the potential penalties for count 1?
Yes, ma'am.
Count 2 likewise is a felonious assault with its own penalties again of 2, 3, 4, 5, 6, 7, or 8 years of a definite sentence, up to 12 years of an indefinite sentence, up to $15,000 fine, or both. Do you understand the potential penalties for count 2?
Yes, ma'am.
Count 3 is a 3rd count of felonious assault, also charged, of course, as a felony, the 2nd degree, with the potential penalties of 2, 3, 4, 5, 6, 7, or 8 years definite prison sentence, up to 12 years indefinite prison sentence, up to $15,000 fine, or both. Do you understand the potential penalties for count 3?
Yes, ma'am.
The count 4 is endangering children. It's charged as a misdemeanor. The 1st degree, it carries potential penalties of up to 180 days in jail, up to $1,000 fine, or both. Do you understand the potential penalties for count 4?
Yes, ma'am.
Count 5 is ordinary assault. It's a misdemeanor. The 1st degree also carrying potential penalties of 180 days in jail, up to $1,000 fine, or both. Do you understand the potential penalties for count 5?
Yes, ma'am.
Count 6 is unlawful restraint. It's a misdemeanor of the 3rd degree, which carries potential penalties of 60 days in jail, $500 fine, or both. Do you understand the potential penalties for count 6?
Yes, ma'am.
Count 7 is another unlawful restraint count, which is again a misdemeanor of the 3rd degree, carrying potential penalties of 60 days in jail, $500 fine, or both. Do you understand the potential penalties for count 7?
Yes, ma'am.
Count 8 is another unlawful restraint with the same penalties of up to 60 days in jail, up to $500 fine, or both. Do you understand the potential penalties for count 8?
Yes, ma'am.
And count 9 is domestic violence. In this particular type of domestic violence is charged as a misdemeanor, the 4th degree, which carries potential penalties of up to 30 days in jail, up to $250 fine, or both. Do you understand the potential penalties for count 9?
Yes, ma'am.
Obviously, it's very serious. We're gonna enter a not guilty plea on your behalf. If you cannot hire your own attorney, we can have one appointed. Are you gonna be able to hire your own or need one appointed?
I need one appointed.
Okay, you'll have to fill out paperwork if you haven't, we will appoint
Scott Petrov.
Attorney Scott Petroff. And we will next talk about bond and what's the state's position on bond.
Yes, Your Honor, the statement asked that bond be set at 50,000 with 10% permitted along with no contact victims.
The state is asking for a $50,000 bond with 10% cash permitted with no contact with the victims. You have the right to make a statement about bond. I just caution you that you don't want to make any statement that could be used against you, but if you want to address just the issue of bond, now would be the time.
It would be nice to be granted an OR bond so that way I can go out and get the evidence that I need. And Your Honor, please keep in mind that the victim in this situation lives in Oak Hill, Ohio. And that's where he and my son resigns. And I'd like to go out there to be able to get the security footage and all the other evidence that I need to prove my innocence in this case.
Okay. Thank you. Anything else you want to say about bond?
No, ma'am.
Okay, I am gonna, given the serious nature of these charges, I am gonna set it at 50,000 with 10% cash permitted. And conditions of bond, in addition, will be that you have to be on the GPS monitoring system, repath, which is an additional $250 per month, with the first month payable up front and each month thereafter an additional $250. You also cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms. You cannot get in any other trouble. No contact with law enforcement resulting in charges or arrest, and no contact with
Nate
Smith.
and Hannah Barkus.
What was the next?
Hannah
Barkus.
Barkus.
Barcus.
Yes.
So no contact directly or indirectly with Nate Smith or Hannah Barkus as a condition, which is part of the reason, of course, for the high bond. Your attorney, however, will have mechanisms with which to try to collect that information, because you cannot go to anywhere this person may be to collect any evidence, and that concerns me. You have to have your attorney do those sorts of things. Next, we'll talk about the schedule of hearings.
I got a question.
Okay.
How do I have 9 accounts in common police court, but I still have the remaining charges in county court? That's double jeopardy. Correct me if I'm wrong.
I don't know what's in county court. It appears that you were indicted here on a number of misdemeanors, so they may all be bound over here. So what happens is there's a procedure where things are filed initially when someone's arrested, and we've not had grand jury sessions yet since the alleged incident. You're in county court with Judge Barr. When there's a felony involved in them, there's a preliminary hearing or a waiver of preliminary hearing. The case then is transferred or bound over, it's called, to common pleas court, which is this court you're in here. So none of those cases are in that other court now. They've all been shifted to be over here. And the grand jury has now indicted you on a number of things, those felonious assaults as well as those misdemeanors. So they're all in this court now.
Okay, and may I have contact with my son?
I don't know who's your son.
Xavier Lambert.
Who is Xavier what?
Lambert, Lambert.
How old is that child?
He is 1 year old.
What and who's taking care of him?
My baby mom, my baby mama's mom. So I can call my mom's mom and talk to my son.
Who are those people? What are their names?
My baby mom's mom is Lori Barkus, and the other one is Hannah Barkus. I don't want to have contact with Hannah. I want to have contact with Lori to talk to my son.
If it's interpreted in any way of you trying to be in contact with Hannah, it could be a problem. My advice is for you to ask your attorney and he can file particular paperwork to try to make sure you're protected before you try to make any contact. Because we want to be able to hear whether you're the child's mother's mother will even want you to have contact with her. At this point, I'm not going to tell you to do that because I'm afraid it could cause you potentially to be violating the conditions of bond. But again, when you get with your attorney, he can talk to you about that. Of course, a 1-year-old, it's not like you can call them on the phone or anything, but you know, he'll be able to work on that. Now, the hearings will be.
We'll set an initial pretrial for July the 20th at 10:30. A final pretrial and motions hearing for August the 10th at 11:15. And a jury trial date of August the 25th at 8.
Those dates are all going to be on your arraignment entry that you'll receive today. Those dates are on page 2. Page 1 will have information such as your attorney and his contact information, your bond, and your conditions of bond that we're just talking about, which means no contact directly or indirectly with Nate Smith or Hannah Barkus. You started to ask something else. What was your other question?
Oh, no.
You don't know? Okay. There'll be also an order that you have to be fingerprinted and photographed for this indictment. Do you have any other questions?
No, ma'am.
Okay. Anything else from the state?
No, you're on.
All right. Thank you. We will see you then at your initial pretrial soon. Who do we have next?
Judge, did you get my message on Lindsay?
Oh, I'm sorry. No, I haven't
She
looked.
sent a message that she's on the way for a title. She's running behind.
Okay. Also, she is coming with Tuttle. So that answers that question. All right. So what's your name?
Case Will.
Yes, this is Mr.
CR 069.
Thank you. We are on record in the Meigs County Common Pleas Court in State versus Will, case number 25 CR 069. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
Oh, it's 26?
Yes, ma'am.
I have it as, oh, did I say 25?
Yes,
Okay. Oh, okay, that's what. So to correct my, thank you for telling me that. It is, the case number is 26 CR 069. I misstated that. If you would, please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. For the record, I'm Linda Warner, the Common Pleas Court judge, and you are being recorded and televised through the Zoom channel and the Zoom application, as well as our YouTube channel. So you need to be advised of that. Please state your name
Chase Franklin Will.
and your address.
Don't have one.
Did you have a place where you can receive mail?
Nope.
Where were you last staying before you were arrested?
A bando.
Oh, excuse me?
A bando.
I can't understand the word say that a little slower.
Somebody's property that they don't live in anymore.
Okay, abandoned property. Was
Yeah.
that within Meigs County?
Yeah.
Okay, so one address you can use would be the Meigs County Department of Job and Family Services, but you'd have to make sure you go there to pick up your mail. We have to have someplace to send your mail if and when you're out of jail. So do you know where that is in Middleport?
Is it the one behind the bar?
Which bar?
Best
Wayne's?
or Wayne's? Yeah.
Yes, it is back there. Yes.
Okay. Yeah. I know.
Okay. So we will use that. It's 175 Race Street, Middleport, Ohio as your address. What's your phone number?
Don't have one.
Do you have an email?
Nope.
Oh. All right, do you have a phone number where someone, you can get a message that somebody else's number?
No,
Was that yes or no?
no.
Okay. You don't have an attorney yet. We'll talk about getting you one in a moment. We do have the state's attorney.
Yes, Connor Sidney Whiting, Meigs County Assistant Prosecuting Attorney on behalf of the state.
All right. Mr. Will, you were indicted by the Meigs County Common Pleas Court Grand Jury on July 1st, 2026. Did you receive a copy of that indictment?
Yeah,
Was it more than 24 hours ago?
it was the first, yeah.
Okay, you have the right to have the indictment read to you in its entirety, or it's a right you may waive if you want to waive the reading. If you're good at understanding written English, do you want me to read it to you, or do you want to waive the reading?
You can gotta read it.
Okay, it's in the Common Pleas Court of Meigs County, Ohio, State of Ohio, County of Meigs, case number 26 CR 069. Indictment: Chase F. Will, date of birth 11/28/01, social security number ending in 3804. In the Common Pleas Court of Meigs County, Ohio, of the term January in the year of our Lord 2026 July session, the jurors of the grand jury of the state of Ohio within and for the body of the county aforesaid being duly impaneled and sworn and charged to inquire and present all offenses whatever committed within the limits of said county on their oaths in the name and by the authority of the state of Ohio, count one, do find and present that Chase F. Will, on or about the 16th day of June 2026 in the county of Meigs, state of Ohio aforesaid, did commit the crime of attempted burglary, in that Chase F. Will did purposely or knowingly, and when purpose or knowledge is sufficient culpability for the commission of an offense, did engage in conduct that, if successful, would constitute or result in the offense of burglary, in violation of section 2911.12B of the Ohio Revised Code, a felony of the fourth degree, in violation of section 2923.02A of the Ohio Revised Code, a felony of the fifth degree, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Count two, do find and present that Chase F. Will, on or about the 16th day of June 2026 in the county of Meigs and state of Ohio aforesaid did commit the crime of resisting arrest, and that Chase F. Will did recklessly or by force resist or interfere with the lawful arrest of the person or another in violation of section 2921.33A of the Ohio Revised Code, a misdemeanor of the first degree, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Count three, do find and present that Chase F. Will, on or about the 16th day of June 2026 in the county of Meigs and state of Ohio aforesaid did commit the crime of criminal trespass, in that Chase F. Will did, without privilege to do so, knowingly enter or remain on the land or premises of another in violation of section 2911.21A of the Ohio Revised Code, a misdemeanor of the fourth degree, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. The indictment is signed by the prosecuting attorney as well as the grand jury foreperson. It is a finding of a true bill. Did you hear the reading of the indictment?
Yes, ma'am.
I will note, having read the indictment, that there would be a victim or victims. Was the victim or were the victims notified?
Yes, sir.
Are they present? Did you anticipate they would be? Now I'm going to tell you the potential penalties for each of these counts. Count one being attempted burglary is a felony of the fifth degree. It carries potential penalties of 6, 7, 8, 9, 10, 11, or 12 months in prison, a fine of up to $2,500 or both. Do you understand the potential penalties for count one?
Yeah,
Count two is resisting arrest, a misdemeanor of the first degree, carrying potential penalties of 180 days in jail, a fine of up to $1,000 or both. Do you understand the potential penalties for count two?
yeah,
Count three is criminal trespass, a misdemeanor of the fourth degree, carrying potential penalties of 30 days in jail, a fine of up to $250 or both. Do you understand the potential penalties for count three?
yeah.
We're going to enter a not guilty plea on your behalf at this time. You need to have an attorney to assist you. If you cannot afford one, one can be appointed. Are you going to be able to hire your own, or you need one appointed?
I need one appointed, so.
Okay, you have to fill out some paperwork if you haven't already, but we will appoint
Britt Wiseman.
attorney Britt Wiseman. His contact information will be provided today in some paperwork. Next, we'll talk about bond. What's the state's position on bond?
Yes, Sharon, the state would ask for an OR bond in this matter, but like he's serving a sentence from Meigs County Court and he has an out date of December 20th. And then no contact with the victims as well.
Okay, and the victims are
Melinda Queen.
Melinda Queen.
And
How about I have contact with my aunt?
Wait a second.
Diana Landers.
Anyone else? Okay, the state is recommending an OR bond in this particular case. Do you have any statement about bond?
Can I just have a plea deal?
You'll have to work with your attorney to talk about a plea deal. And then your attorney will talk to the prosecutor. Do you have any statement about bond?
No.
So the bond will be set at an OR, personal recognizance or unrecognized bond. You will have conditions of bond that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do anything with firearms. You can't get in any other trouble. No contact with law enforcement resulting in charges or arrest. And another condition of bond is you cannot have any contact with, directly or indirectly, Melinda Queen or Diana Landers. And with that, then we'll set hearing dates for.
We will set an initial pretrial for August the 10th at 2:45. A final pretrial and motions hearing for September the 14th at 3. And then a jury trial date of October the 6th at 8.
Those dates will all be on the same paperwork that I mentioned earlier, that you'll have your attorney's information and your bond information. Also, there'll be an order that you have to be fingerprinted, photographed, and DNA collected on this indictment. Do you have any questions?
No.
Okay. Is there anyone else there?
Yes,
Okay, who do we have now?
Anderson, and we still have a female, Evelyn.
Okay, we'll do Mr. Anderson. I always say female.
State versus Anderson.
CR059.
Thank you. Too small on my screen. We are on record in the Meigs County Common Pleas Court in State versus Anderson, 26 CR 059. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
I'm notifying you that we are streaming this through the Zoom application and a YouTube channel. State your name
Thomas Franklin Anderson.
and what is your address?
I don't have one.
Okay, where were you last staying before you were arrested?
706 Elm Street in Racine, Ohio. 45.
771, okay. But you're not going to be able to be at that address, I take it. Where would you
For 14 years.
where would you like to be able to receive your mail?
The Rutland Post Office quit on Friday, and my brother is putting up mailbox in front of Joy's house.
Do you know the address there?
209 Salem Street, Rutland, Ohio, 45775.
So you can get mail there?
Yeah,
Thank you. What is your phone number?
I don't have one.
Do you have a place where a message can be left, like your brother's?
Yeah,
What's that number? What's that number?
407423068.
Okay, and that is your brother's?
Yes,
And what is his name?
sister,
Or your sister, what is her name?
Joy Anderson, my brother's name is, Joe Anderson.
Okay, thank you. Do you have an email address?
I don't remember it.
Okay, that's fine if you're not using it. You don't have an attorney with you, but we'll talk about getting you one in a moment. We do have the state's attorney. She's going to identify herself.
Yes, Your Honor, Cindy Whiting, Meigs County Assistant Prosecuting Attorney, Herman County State.
Thank you. You were present before me and in jail because you were indicted by the Meigs County Common Pleas Court grand jury. It's a one-count indictment. The indictment was on July 1st, 2026. Have you received a copy of that indictment?
Yes,
Okay, it is a one count, I'm sorry.
it was, more than 24 hours ago.
Okay, great. You've listened to the last three people. Thank you for telling me that. And you have the right to have the indictment read to you, or if you're good at reading and understanding written English, you can waive the reading. Do you want me to read it to you, or do you want to waive the reading?
Waive the reading.
Okay, I will tell you the potential penalty since you do not have an attorney with you. The one count is for rape. It is a felony of the first degree. It carries a mandatory prison sentence, which means if you are in fact found guilty, it's required that you go to prison. There's no chance for community control. The potential penalties are 3, 4, 5, 6, 7, 8, 9, 10, or 11 years definite prison sentence, up to 16 and a half indefinite with the tail, up to $20,000 fine, or both. Do you understand the potential penalties?
Yes,
Obviously, it's very serious. We're going to enter a not guilty plea on your behalf, and you need to have an attorney to assist you. If you cannot afford one, one can be appointed. Do you need one appointed, or are you going to hire your own?
I need one appointed.
Okay, we will appoint
Brent White.
attorney Britt Wiseman.
Can
And
I
his,
ask for Denise Bunce?
can you ask for Denise Bunce? She does take these. I mean, do you have a relationship with her already?
Yes, my brother signed a, lemon will to, uh, place my,
I don't, we can appoint Denise. I don't mind because she takes appointments. You, when she switches to Denise. Okay. Yeah, we'll give you Denise Bunce then, because she is on our list of willing to take these
Thank you.
cases. Sure, no problem. Next, we're going to talk about bond. What's the state's position on bond?
Yes, Your Honor, the state would ask that bond continue as it was set in Meigs County Court at $1 million with no 10%, along with no contact with victim.
And the victim as a minor,
Yes.
and the initials are
MC.
M as in Mary
Yes.
and C as in Charles.
Yes.
Okay. So the state is requesting that the bond be the same as was set in county court before the case was bound over and indicted, of $1 million with no 10% cash permitted, with conditions of no contact with the victim directly or indirectly. Do you have any statement that you want to make about bond? I do want to caution you, anything you say could be used against you. So make sure you do not talk about any of the underlying allegations, only about the issue of bond. Do you want to make any statement about bond?
I don't have any, money for the bond.
Okay, I am gonna set it at $1 million with no 10%. And the conditions, if you would make the bond somehow, would be that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do those things with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or arrests. Also, no contact with the victim directly or indirectly, which would mean with the victim's immediate family or household, given that the victim is a minor and that victim's initials are MC. Next, we'll do a hearing schedule.
We will set an initial pretrial for July the 29th at 11:30. A final pretrial and motions hearing for August the 12th at 2. And then a jury trial date of August the 25th at 8.
Those dates are going to be on page 2 of the arraignment entry you'll get today. So make sure you read that, and the contact information for your attorney will be included in that document as well. There'll also be an order that you have to be fingerprinted, photographed, and DNA collected. Do you have any questions?
No, thank you, Judge.
Okay. Thank you. We'll go ahead and let you go back to your cell, and then I think we have, you said a woman?
Yes.
Okay,
Brittany Evelyn.
yeah, she was,
Case number 22 CR 209.
thank you.
Nate versus Evelyn.
We are on record in the Meigs County Common Pleas Court in State versus Evelyn, case number 22 CR 209. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, Miss Evelyn. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I need to advise you that we are live streaming everything through our Zoom application and through a YouTube channel. For the record, state your name
Brittany Evelyn,
and what's your address?
35608 King Ridge Road, Palmer, Ohio, 45769.
What was the name of the road?
King Ridge Road,
Oh, King Ridge. And your phone number?
740-742-5041.
And your email?
EvelynBrittany861@gmail.com.
What was the first word before Brittany?
Evelyn.
Evelyn. Brittany,
Yeah.
okay. That makes sense. Okay, thank you. You're here without an attorney. We'll talk about getting you on a memo. We do have the state's attorney. She's going to identify herself.
Yes, Your Honor. Sydney Whiting, Meigs County Assistant Prosecuting Attorney on behalf of the state.
You were indicted, is this an arraignment, original arraignment?
No.
I was gonna say, this is a PV. I was gonna say, because I remember Miss Evelyn, so this is a PV. So a motion to revoke community control was filed against you. You recall that? Did you receive a copy of that?
Yes, ma'am.
Okay, so I'm going to enter a denial on your behalf at this time until you can have an attorney to assist you through the process. If you cannot afford an attorney, one can be appointed. Do you need one appointed, or are you going to hire your own?
I was just gonna, can I just plead guilty to it?
Well, because you're looking at significant prison time, I won't let you do that until you talk to an attorney. So you really, and you're free to hire your own, or we can appoint someone. We can try to expedite the hearings as quickly as possible, but I don't want you to make any admissions without you having an attorney, since this is, the underlying charges are felony. The underlying conviction is for a felony.
Okay, I need an attorney.
Okay, and we will appoint
Denise Bunce.
Denise Bunce. We'll get her to talk. You can contact her from the jail, and we'll get things done as quickly as possible. Next, we'll talk about bond. What's the state's position on bond?
Yes, Your Honor. The state would ask that bond be set at 25,000 with 10% permitted.
Okay. The state is asking us, they typically do, in a motion to revoke community control, for a bond of $25,000 with 10% cash permitted. Do you have any statement about bond only, not on the underlying allegations on the motion to revoke community control? Any statement about bond?
I'm on bond also for Athens County, and I have a bed ready for amended reads. Can I still do that?
When is the bed available?
Immediately.
I'm sorry, say that again.
Immediately,
Immediately.
yes.
Yes.
The state would be opposed to that only because she was sentenced to go to Star through Meigs County and left Star.
The state is opposed to that at this time because of leaving Star. So at this time, I'm not going to do that. I certainly would reconsider it once we have a hearing, which we'll try to schedule fairly quickly. And that would be,
We will set a probable cause and final PV hearing for July the 16th at 8.
July 16th at 8 a.m. will be the hearing, and we can talk about some more of those options at that time. Conditions of your bond, if you do make the bond, will be that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do those things with firearms, and you can't get any other trouble. No contact with law enforcement resulting in charges for arrest. Do you have any questions?
No, Your Honor.
Okay, then we'll see you on the 16th.
All right, thank you.
Thank you.
That's all you have today. Have a
All
good day.
right. Yeah, have a great day. Bye-bye.
Bye.
So Mr. Tuttle is coming, but we've not seen or heard Lindsay.
I think they're both out in the hallway. If someone
Okay.
wants to go get them.
So Jim?
Yes. I just gave him his.
Oh, okay. But is Lindsay there?
Yeah.
So she can have it filled out with him later.
Asked if you're sitting right before hers and said that she had a date with that.
Say there.
Yeah.
Yeah.
Morning, y'all.
Good morning.
State versus Tuttle.
We are on record in the Meigs County Common Pleas Court in State versus Tuttle, case number 26 CR 058. For the record, I'm Linda Warner, the Common Pleas Court Judge. Mr. Tuttle, please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I need to tell you that we are live streaming everything now on Zoom and on a YouTube channel as well. So you're aware of that. State your name
Yeah,
and what is your address
44330 Whipple Road, Colorado,
and your phone number.
508 1072.
What was the last four?
1072.
107.
Yes.
I just want to make sure I heard it correctly.
107.
And your email.
It is. No, I don't have that memorized.
Okay.
It's just in the phone.
That's all right. You have an attorney. So sometimes when you don't have an attorney, when you first come in, I want to make sure that I have as much information as possible to notify whomever I appoint for you. So give it to your attorney though. That's fine. And your attorney for the record is?
Certainly, Your Honor. My name is Attorney Lindsay Price, and I represent Mr. Tuttle, who's present in the courtroom and seated to my left. We can be reached at 216 East Main Street here in Pomeroy, Ohio. The mailing address is P.O. Box 591, bar number 82002.
And for the state?
Yes, Your Honor. Sydney White, Meigs County Assistant Prosecuting Attorney on behalf of the state.
All right, Mr. Tuttle, you were indicted by the Meigs County Common Pleas Court Grand Jury July 1st, 2026. It's a 2-count indictment. Did you receive a copy of the indictment?
Your Honor, if
No.
correct.
Okay.
Your Honor, if I may.
Yes, please.
He was incarcerated on this charge until approximately 48 hours ago. He had not been served with a copy of the indictment. I spoke to your court staff and your bailiff has served Mr. Tuttle, but that was just a few minutes ago before we came on the record. At this time, we would waive the 24-hour notice, so we may proceed with arraignment this morning.
Okay, and do you want me to read him the indictment and go through the potential penalties with them?
If you don't mind, Your Honor.
Okay. So the indictment reads, in the Common Pleas Court of Meigs County, Ohio, State of Ohio, County of Meigs, case number 26 CR 058, indictment. Scott M. Tuttle, date of birth 6/11/80, social security number ending in 9138. In the Common Pleas Court of Meigs County, Ohio, of the term January in the year of our Lord 2026 July session. The jurors of the grand jury of the state of Ohio within and for the body of the county aforesaid being duly impaneled and sworn and charged to inquire of and present all offenses whatever committed within the limits of said county on their oaths in the name and by the authority of the state of Ohio, count 1. Do find and present that Scott M. Tuttle on or about the 25th day of May 2026 in the county of Meigs and state of Ohio aforesaid did commit the crime of improperly discharging a firearm at or into a habitation, and that Scott M. Tuttle did, without privilege, do so, knowingly discharge a firearm at or into an occupied structure that is a permanent or temporary habitation of any individual in violation of section 2923.161A1 of the Ohio Revised Code, being a felony of the second degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 2, do find and present that Scott M. Tuttle on or about the 25th day of May, 2026, in the county of Meigs and state of Ohio aforesaid, did commit the crime of using weapons while intoxicated, in that Scott M. Tuttle did, while under the influence of alcohol or any drug of abuse, carry or use any firearm or dangerous ordinance in violation of section 2923.15A of the Ohio Revised Code, a misdemeanor of the first degree, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. The indictment is signed by the prosecuting attorney as well as the grand jury foreperson, and it is considered a true bill. Did you hear the reading of the indictment?
Yes.
Count one, improperly discharging a firearm at or into a habitation is a felony of the second degree, carrying potential penalties of 2, 3, 4, 5, 6, 7, or 8 years definite incarceration, up to 12 years with an indefinite tail, up to $15,000 fine, or both. Do you understand the potential penalties for count one? Count two, using weapons while intoxicated is a misdemeanor of the first degree, carrying potential penalties of up to 180 days in jail, up to $1,000 fine, or both. Do you have any questions about the potential penalties for count two?
On this one.
Okay, and at this time, I am asking, what is your plea? Your counsel may want to answer that.
Your Honor, his plea at this time is not guilty.
All right, and next we'll talk about bond. What's the state's position on bond?
Yes, Your Honor, the state would ask that bond continue as it was previously set Meigs County Court at 50,000 with no 10%, which was posted.
We have no objection to that, Your Honor.
Along with no contact with victims.
I was gonna say, I didn't realize really until I ended up reading the entire indictment, there would be there would be victims or victim. Was the victim notified?
Yes, Your Honor.
Is the victim present? Anticipate the victim would be present?
No.
Okay, we will ask the defense now if they have a statement about bond.
Your Honor, we have no objection to the bond remaining as it is, as Mr. Tuttle has currently been bonded out.
Okay, so we will leave the bond as was set in county court at $50,000 with no 10% permitted. Other conditions of bond, Mr. Tuttle, is that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do anything with a firearm. You can't get any other trouble. No contact with law enforcement resulting in charges or arrest, and no contact with James
And Marcia.
and Marcia. Russell, do you understand the conditions of bond? Okay, and next we'll have a hearing schedule.
We will set,
Sorry, Your Honor, I need to get my calendar out.
Okay, sure.
I'm ready when you are.
okay. August the 11th. I'm looking at Tuesdays, because are you usually already here for county court those days?
First, third, and fifth Tuesdays of the month.
First, third, and fifth.
That would be probably the second Tuesday.
Yeah, the 11th.
Yeah, so okay, what about the 18th?
18th, I'm already in Athens before that, but. September 1st works, August 4th.
Okay, let's,
We're gonna be in a murder trial. August
Okay,
1st.
how about not August 4th?
Huh?
How about not August?
Yeah, yeah, you'd be sitting around waiting.
September the 1st then.
Okay, great.
What time?
All I have is county court, so morning is better, but
Okay, what about September the 1st at 9?
perfect.
Right, the final pretrial and motions hearing, what about October the 6th? At 9?
I am in juvenile court at 9.
Okay, what about 10? Or in the afternoon?
Can we do like 10:30?
Yeah, okay, October the 6th at 10:30. And then a jury trial date, what about November 10th?
There's not, I can make that day work.
Okay, November 10th at 8 AM.
And Mr. Tuttle, you're gonna have to be fingerprinted and photographed and DNA collected for this indictment if that has not already happened. We can check before you leave. Don't leave until
Leave that up to,
regional.
yes,
Okay. On this case or on something different?
these charges.
Okay,
I don't know that he's been incarcerated on any other charge recently.
okay, okay, that's fine.
Or ever for that matter.
Okay, okay. Just want to make sure that that's made it to where it needs to go. If for some reason it fell in that black hole that goes between places sometimes. We'll just double check before you leave here today. Is there anything else from the state?
No, Your Honor.
Anything else from defense?
No, Your Honor.
All right, thank you very much.
Thank
We'll
you.
see you soon. Good thing we started at 8 instead of the original plan.
I know, but they didn't get involved, and we didn't get done with the jail until
Well, I
8:47.
think we have from 8 to 9.
I have one.
I think we have a full hour.
I thought it was just 8 to 8:30.
We can double